Perfect. So welcome everyone to the next episode of the Tort Law and Social Equality Project. As I uh, briefly mentioned, this is a trends or intercontinental version of the speaker series. We're formally located in Toronto, in Canada, but we have two speakers coming from all corners of the globe and all corners, all different time zones as well. And so we're very grateful for accommodating the 3 p.m. start with various times. The first, Vicki Evans, who is a lecturer in private law at the Dixon Boone School of Law at King's College London. Her research focuses on the intersection of property law and torts, and she'll be presenting a co-authored paper project with Jodi Gardner, who's the Brian Coote Chair of Private Law at the University of Auckland in New Zealand. And her research focuses on the intersection of private law and social policy. Vicki and Jodi will be speaking on a talk entitled Defective Buildings Can Be Such a Nuisance, the Limits of Nuisance, Getting into Fearn, Getting Out of Grenfell. And they'll be speaking for about 45 minutes, give or take. After that, we'll open it up for a Q&A, and I'll run that. But I guess over to Vicki and Jodi, and in particular, Vicki, feel free to get your slides up, and we can go from there. Hopefully everybody can see these. Perfect.
Is that sharing now?
Yeah, looks good to me. Thanks, Vicki.
Thank you very much, Anthony, and thank you for the invitation to present this research in such a perfect forum, and for everyone coming across the different time zones. It's particularly wonderful to have Sue Bright here because we will definitely be picking her brains about her theory on this because it's so central to the fantastic work that she's been doing. Anthony and asked Vicki and I earlier how we came across to know each other and how we came across to do this project. And it's quite a lovely story in that I was reviewing Vicki's monograph about the intersection between property and tort, which is something that I had not thought that deeply about previously. But it just opened up this world of kind of possibilities to me. And I have been very fortunate to work with Sue Bright and Ben McFarlane and a number of others on a project looking at enforcing rights and getting redress for victims of defective cladding premises and or any sort of defective building work. And it started me thinking about kind of how we can use this intersection between tort and property to provide additional rights for people. And then when Fearn came out and caused such an incredible stir amongst the private law community about this expansion of previous beliefs about what nuisance entailed, and particularly kind of Lord Leggett's judgment about the expansion of this, I started thinking, well, if we can expand nuisance, how can we expand nuisance? And if we really take the unreasonable interference on its kind of words and terms, could we think that defective buildings and living in defective buildings could be a nuisance? And I kind of had this light bulb moment when I remembered Vicki's book. And so I sent her an email out of the blue just saying, hey, I've had this incredibly random idea, and I'm sure a lot of people would think it's slightly bonkers, but would you want to do something on it with me? And Vicki, who obviously thinks on the same slightly bonkers level as me, replied and very enthusiastically. And so we've already done a review piece on this, which discussed the kind of budding idea, and now we're looking to do a full piece determining if and how we could apply the concepts of nuisance in Fearn to defective buildings. So that's just a bit of a background about the project and how we came together. But if we move on, thanks, Vicki. Today, the outline of the presentation follows largely the format of the article that we're writing. So I will start by talking about the challenges of defective buildings, and then I'll pass over to Vicki, who'll talk about the tort and property divide and solutions to defective cladding, looking at nuisance after Fearn. And then Vicki will kindly hand it back to me, and I'll talk about some ongoing challenges, because even if someone accepts our argument put forward, there's still a lot of procedural and substantive challenges to enforcing these rights. And then I'll have some brief concluding thoughts. Looking at the challenges of defective buildings, and there is no, I feel like I am the apprentice speaking to the master with Sue in the room, but there is a number of challenges of enforcing defective buildings, and Grenfell Fire really highlighted the human cost that the defective buildings, particularly defective claddings, can have. The use of the improper material resulted in a combustible building and cost 72 people their lives. This was not an isolated incident. There are currently, we guess, between 10,000 and 12,000 buildings just in the UK needing what has been classified as life-critical safety work. So if you think about the number of people and families that would be living in these medium and high-rise buildings, this is a really critical issue to be addressed. And it's not an isolated incident. It's not something that's just a problem with the UK. There's been many similar situations around the world. Defective cladding has been used in multiple countries, including Australia. But it's not just defective claddings, defective buildings. Kind of different countries can have their own take on the issues. So in Aotearoa, New Zealand, for example, we have had leaky buildings, which was when building materials were used in a substandard way. And later on, it was discovered that they were leaky and that they created a whole bunch of rot and mold. And that has had a number of health complications for people there. And again, it's similar to the defective cladding, that the ability to enforce rights and have these fixed has been an ongoing problem. And in many instances, it costs more to fix the leaky building in Aotearoa, New Zealand, than it does to knock the building down and start again, which has had a number of ongoing issues in terms of equality and access to housing, and has meant that some of the people in the most vulnerable situations have ended up in these leaky buildings, which have not been adequately rectified. And so we've seen this issue over and over again with defective buildings. And you would think that there would be a number of potential mechanisms through the private law to obtain redress and to rectify these issues. You have contract, you have tort, you have statute. But the work done by Sue and Ben McFarlane has highlighted the significant challenges and limited mechanisms that exist in private law to address and rectify these issues, both on an individual rights level, but on a collective rights level. So I'll now hand over to Vicki. Oh, actually, I think I've got maybe one more slide. Yes. Okay.
So this is just sorry.
Yeah. So in the UK, there were some attempts to provide easier paths to create rectification and to create potentially compensation if rectification was not preferred or too difficult. And the Building Safety Act was enacted in 2022. This has provided some assistance, and we have had a number of successful cases about rectification. But there are still huge barriers that exist to litigation. The Act is still incredibly difficult to enforce, and particularly on a collective level. So if you think about the high-rise buildings and you think about homes, you've got many different people with a lot of different legal interests. You'll have tenants, you'll have owners, you'll have people living in them, you'll have people who've purchased them for investment. And actually enforcing these rights on a collective level, bringing everyone together, has created a number of different challenges. And I have been fortunate enough to write about this with the fabulous Simone Degling from the University of New South Wales, looking at how we could use collective redress to do that. But again, there is still these huge barriers that exist to getting rectification and justice in this area. And this is when I had the idea, well, could the tort and property law intersection provide a potential solution, or at least another path forward for this, and could the much criticised and quite controversial case of Fearn and Tate Gallery be used for social good instead of protecting wealthy millionaires in central London? And just to kind of highlight how these two fit together in our minds, we've got two quotes. And the first is from Sue Bright and Ben McFarlane from a chapter in an edited collection in 2023. Where they've said, since the Grenfell Tower fire in London on the 14th of June 2017, many thousands of residential blocks of flats in England and Wales have found to have serious fire safety problems resulting from the widespread use of combustible cladding and insulation, wooden balconies, and the emission of cavity barriers. And in that same year, Lord Leggett commented that it's not difficult to imagine how oppressive living in such circumstances would feel as an ordinary person. And unfortunately, he was not talking about the people who were living in these buildings with fire safety problems and potential life-critical need for rectification. He was actually talking about the millionaire owners of the flats that were at the centre of Fearn and Tate Gallery. And so we thought, well, if we really do care about oppressive living circumstances for ordinary people, then maybe we should be thinking about how nuisance could be used to address the issue in Sue and Ben's quote, as opposed to the situation in Fearn and Tate Gallery. And now I will hand over to the fabulous Vicki.
Thank you. So when Jodi got in contact with me, one of my starting points was, well, at least part of this problem is caused or at least exacerbated by property law, and specifically how we model flat ownership in the sort of common law system. So there are lots of variations of how you could own high-rise buildings, but I'm going to steal Sue's terminology from one of her blog posts and talk about only privately owned blocks. And it's a bit of an oversimplification, but the basic idea is that in privately owned blocks, there is an independent landlord that holds the freehold of the building, which constitutes an estate in land. And then the individual flats are sort of owned on a long leasehold system, sometimes sort of 999 years. And this also represents a separate and distinct estate in land. So the long leasehold gives the holders rights are sort of akin to ownership for the period of time that they have the lease. But importantly, they don't have control of the building as a whole, and the structure and the common parts remain under the control of the freeholder. So the individual leaseholder doesn't have any sort of estate or interest or sort of control of the whole building. And that basic explanation illustrates part of the problem. So those that are suffering, the leaseholders with sort of unsafe and devalued flats, aren't the people that are in the position or have the control to be able to remedy it. So rather, it's the freeholder, the landlord, that has to want to remediate the building and has the power to remediate. So the starting point for me was, well, this is a property law problem. So why do we not pause and think, well, what can property law do? But the problem is that property law itself doesn't provide any answers, in that we don't have any remedies in the English common law system that are proprietary. So instead, property law creates the rights and then relies on other areas of law to protect them. And my background is thinking of the primary remedy of this as tort law. So we need to look to tort, and specifically the property torts or land-based torts, for what property might be able to do to help. And the question then becomes, well, what can tort law or the property torts do to help? And we thought that there is a role for private nuisance here. So private nuisance as a tort deals with violations of real property rights. And while the other torts, like trespass, talk about sort of protecting the right of exclusion and this sort of hard and fast lines, nuisance has been said to sort of add colour to the picture. So nuisance in Fearn was confirmed about not protecting the right to exclude, but rather it's about balancing the rights of neighbours, about controlling the terms on which we can relate to each other as owners. So what would it be fair and reasonable to ask of our neighbours? And so it highlights how we should use property and when we should limit so that we don't unfairly affect other people. Before we look specifically at how we think a claim in nuisance could be framed for unsafe cladding, I want to make two preliminary points to sort of justify why we should be in the remit of nuisance. So nuisance as an action is focused on protecting the claimant's use and enjoyment of land. And it's normally protecting the use and enjoyment of land where another piece of land is being used in a way which limits the other pieces of land's use and enjoyment. So in this typical flat ownership structure we have in the common law, we do have two different parties holding two different pieces of land or two different estates. So because the leasehold structure splits the control, we have something that can be conceived of as neighbouring plots of land, neighbouring estates, which brings us within the tort of nuisance. So we have one plot of land which is creating or causing or adopting a problem that is then affecting the other plot. So we can see that the sort of two estate thing in easements a lot as well. So that's why we think we can potentially come within nuisance. This Canadian case of Latham, I think, although it was not upheld, I think some of the discussion in there also supports the fact that this can be seen as sort of two different plots. And the second point is that unsafe cladding is affecting the usability or the use and enjoyment of the land in question. So we can draw on Fearn here. So for those that are not as familiar with Fearn, in Fearn, the claimants were long leaseholders of luxury flats, a luxury development known as Neo Bankside. And this was opposite the extension of the Tate Gallery known as the Blavatnik. And the Blavatnik has a viewing gallery which gives panoramic views over London, but as well as giving panoramic views over London, it also gives panoramic and unobstructed views into the claimants' flats through their floor-to-ceiling windows. And despite notices, which you can see on the picture on the slides, asking the visitors of the Tate to respect the privacy of the neighbours, a significant number of visitors took photos, peered into, and even waved at the occupants of the flats. So the claimants argued that this constituted a nuisance, and the Supreme Court by majority agreed that this type of visual intrusion could be a nuisance, but also that it did amount to a nuisance on the facts. So while the decision is interesting, I'm more interested in what Fearn did to nuisance in terms of how it changed the scope and the approach of nuisance to allow that claim. But going back to the quote that Jodi started with earlier, if you look at it a bit more fully, you can see that it's talking about how oppressive living in this would be, much like being on display in a zoo, and it's hardly surprising that a judge would think that this level of intrusion was interfering with the use and enjoyment of land. And I think we can use this as an analogy because the literature surrounding the cladding scandal, I think to actually pull out a quote from Sue, is littered with heartbreaking stories of financial fears, dashed hopes, and destroyed life plans. So there's surely an analogy here that causing one to fear for their own safety and live with the extreme stress and uncertainty that cladding causes is surely the similar level of intrusion to this quote. And actually, the right protected post-Fearn, right in sort of inverted commas, is this right to use and enjoy land. So from that starting point of justifying nuisance, we want to elucidate more fully how you would have a potential claim in nuisance for unsafe cladding or defective buildings. And while we recognise that this isn't the normal remit of nuisance, we think this is possible post-Fearn because Fearn really did open up the scope of nuisance for new types of claim. And we want to show how the scope and approach of nuisance is now fully sort of allows this type of action to potentially be brought. So I'm going to take you through basically the judgment of Lord Leggett, who delivered the majority judgment, because he set out a series of core principles of nuisance. And these provide us with a new approach, although under the guise of simply re-articulating the core principles that already existed, the sort of spin he put on them in that case is helpful for us here. So the first core principle of nuisance is that nuisance is taught to land. So it protects the utility and amenity of the land rather than the personal discomforts of those occupying. And we've already explained that we think this is a reason that unsafe cladding can fall within the action. So unsafe cladding, like visual intrusion in Fearn, affects the amenity value of the land. The land isn't able to be used and enjoyed in a way that a flat would normally. So it can't be sold or mortgaged, it can't be comfortably lived in. And there's some blocks in this country, so cardinal lofts, that can't be lived in or at all, or had at least a really long period of not being able to be occupied. The second core principle is that nuisance can be caused by any means. So there's no a priori limit of what can constitute a nuisance. So Lord Legate made clear that while often it's a physical invasion or an emanation, this is no longer a requirement or wasn't a requirement. So this puts an end to, or at least suggests that the physical invasion view of nuisance doesn't reflect the law as it currently stands. And put together, these two were fundamental in allowing visual intrusion to potentially be a nuisance. And similarly, they're really important to allowing our type of claim to be a nuisance. It sort of clears us our first hurdle. The next core inquiry sets out the primary question of any nuisance claim. So there must be a substantial interference with a claimant's ordinary use of their land. So this first part is we need to have a substantial interference, and we think there's potentially three different ways this claim could be articulated, or potentially more, but these are sort of ones that sort of jumped off the page to us. So the first, which I think is now less promising following the Supreme Court decision in Davis and Bridgend County Borough Council, is that the amenity of the land has been reduced because the reduced value of the land and the inability of the claimants to sell or mortgage the land until it's rectified. So while we can't have claims only based on a reduction in value in tort of nuisance, some claims are allowed based partly or somehow framed on the reduction in value, and we saw that in Williams and Network Rail. So in Williams and Network Rail, which was a Japanese knotweed case, the Court of Appeal reframed a case which would otherwise be a pure economic loss case, saying that the encroachment of Japanese knotweed, although not causing physical damage to the land, interfered with the amenity value by imposing an increased difficulty to develop, an ability to develop the land, which meant that the claimant would have to spend more money if they wanted to, for example, build an extension. And they, by articulating it that way, they were able to say that this isn't a claim for pure economic loss and it's about the amenity value of the land. So we thought our tentative sort of first conclusion was we can do the same thing. So we can frame cladding as an immediate burden to rectify, to allow development or remortgaging or selling. But more recently in Davis, the Supreme Court seems to have put a bit of a bar on that. So this was another Japanese knotweed case. But in this case, the Japanese knotweed had already been dealt with, but the claimants were trying to argue that there was a diminution in their value of their properties based on the stigma of previously having Japanese knotweed. There were other obvious ways that they could have framed this case that the Supreme Court went through and was almost a bit confused as to why they hadn't framed it in these ways. But because it was framed in that way, the court said that actually no, because but for the wrongdoing, there would still have been that diminution, because the diminution in value came at the time of the encroachment as opposed to at the time where the claimants were in control of the land. And this importation of the but-for test into nuisance in this case would likely be the problem here. So the courts could very easily say that the diminution in value of the flats came when the cladding was put on it, when they were built, rather than when we found out about the problem with unsafe cladding. So I think that potentially is going to be a more difficult claim to make. So the better reformulation is one based on the reduction in utility and amenity more broadly. So linking this back to that quote from Lord Legate and an analogy being drawn with fearing for your safety is a similar sort of level of intrusion into the ordinary use and enjoyment of your land as being observed and watched was in Fearn. Because the media is full of stories of sort of bankruptcy, suicide, leaseholders unable to move because of jobs, not being able to care for family members, not being able to start families, splitting up or having to stay together in the house because they haven't got the ability to move and continue on with their lives. And our thought is that surely the freedom to conduct your own life with certainty about your safety should fall within nuisance in the same way that being able to conduct your life without being watched falls within nuisance. And I go back to the idea that it's an important recognition of the relationship between property and nuisance is to think about, well, what accepting or refusing a claiming nuisance means for property, means for the property right. So if we say that there is no claim here, it means that feeling unsafe with flammable cladding, it's not actionable. That's not part of what you have as a property right. And Emma Lees, when she was talking about the Court of Appeal decision in Fearn, which was decided the opposite way, said that there was something quite troubling or problematic about a conclusion that an ownership right in a property doesn't encompass the ability to provide oneself with a safe and private place. Now, we can say exactly the same, but with the emphasis on safe as opposed to private. And it would be really strange if freedom from visual intrusion was part of a property right, but safety and freedom from unsafe cladding wasn't. And the final iteration is one more strongly based on dangerousness. So we get support from this from the work of John Goldberg, and in John Goldberg's book, he uses an example of explosives being dropped over land and not knowing where the explosives were dropped and knowing that telephone signals could interfere and mean that there was an explosion. And when a potential plaintiff in this case finds out about this, hypothetically, he would decide not to return to his house because there's a risk that it wasn't safe for him to return. That he says that this would be a nuisance claim. So even if a couple of weeks later, the company finds the missiles unexploded somewhere, the fact that you have been held and felt like you couldn't return to your land would be capable of being a nuisance. So he talks about creating this kind of dangerousness and the sword of Damocles holding over. And we think that's kind of the same situation that we have here. These are sort of three different articulations of our core argument. And the second aspect of the core inquiry is that we now afford priority to the general and ordinary use of land. So a defendant's activity, even if it substantially interferes, will not be a nuisance if what they're doing themselves is just ordinary use of land. And we don't think that a landlord or a freeholder's behaviour could ever be described as just ordinary use of their estate, because with the cladding being proven to be unsafe and with the government calling for it to be removed, especially in light of the Building Safety Act sort of duties they've placed on landlords, it doesn't seem reasonable for them to have not done anything. And it's actually worth noticing here that actually it's been quite critiqued, this reframing of the reasonableness criteria in nuisance as one of common and ordinary use. So it's been said to make it an imbalanced balancing exercise, but we wanted to use the imbalanced balancing exercise to actually help the property outsider or the sort of people in tort law as opposed to the rich parties like it was in Fearn. The other core principles are on the screen, but don't cause an issue. So I will hand back over to Jodi to finish off.
Thank you very much. So if we can have these core principles accepted, and if there is the potential to extend nuisance in that way to cover these types of defective premises, it will be a big step forward and a lot of issues to overcome. But we just want to finish by saying that won't be the end of the picture, because there will still be a lot of other issues associated with it. We've highlighted a few things on the slide, and so we just wanted to emphasize that there will still be a number of procedural and substantive issues. Obviously, limitation periods, that's been largely addressed by legislation in the building BSA. But how would that work with tort in the limitation periods, and when would that start, and could that limit any sort of potential action? We've got the services charges issues that cause a number of kind of barriers there. One of the other ones is it was previously thought that the state of the premises alone could not be capable of being a nuisance. So this links into whether the landlord should be held liable, because the question arises is, should landlords be liable for nuisance regarding just the state of the premises? Or, another way to look at it is whether the physical attributes of a building themselves are capable of being a nuisance as opposed to an outside issue. Now, it had previously been thought that the state of the premises couldn't be capable of being a nuisance. But again, Lord Legate and Fearn has opened the door, or potentially opened the door for us in this regard. And in the decision, Lord Legate commented, when discussing whether the state of the premises alone could be capable of being a nuisance, he said, I would not wish to rule out the possibility that there could be extreme cases where the design or construction of a building is so unusual and far from anything that could actually be expected that it might do so. So as in, it might be able to constitute a nuisance. And here we've got kind of some arguments for and maybe some arguments against. Obviously, living in an unsafe building is, you would think, an extreme case of the design or construction of a building, so that it would possibly allow this issue to be overcome. However, it says so unusual or far from anything that could be expected. The issue that you might run into here is a potential floodgates, that we have so many buildings like this that they could say, well, it's not actually so unusual and far from anything that might be expected because, up to 12,000 other buildings have that. So that quote has potentially opened the door, but we have to see what kind of emphasis is put on it. Other issues that can continue to arise will be, well, who is the tortfeasor? Is it the landlord of the flats? But then what if you've got a free, someone who owns their flat, or at least has the leaseholder? Who would they have the right against? Will be very different compared to people who are renting flats out. So who has standing to sue and who is a tortfeasor kind of go hand in hand, because the different types of living arrangements will create different potential property rights and interests, and potentially different people to bring a claim against, so different tortfeasors. And this will have to be thought through because unlike Fearn and Tate Gallery, when there was a limited number of people who had largely the same interest, if you look at a defectively clad building, you can have many different people with many different interests in it. And some might have tortfeasors that others don't. So if you're renting, you might argue that the person you're renting from could be a tortfeasor, whereas if you own the property outright, you won't have that right. So it's about kind of just going through and thinking about how we align who has the right to sue and who they can bring a claim against. And this is where collective redress comes into the picture. Because at the moment in the UK, there are limited abilities to bring collective redress, and you have to show that same or shared interest to be able to use the statutory mechanisms in place. And so whether there would be sufficient overlaps and similarities between the different parties to be able to fulfill those procedural mechanisms to have collective redress is another question that would have to be considered. And the courts have done some slightly weird and wonderful things in this regard to defining that and creating a two-stage test. So our plan is to go through that quite briefly, but highlight how collective redress might work in these circumstances, but indicating it is by no means a straightforward part of the equation. So just finishing up on concluding thoughts. We're well aware that what we're saying is quite controversial, and that when we have kind of pegged the idea at people straight away, that their first reaction is, oh God, this is not in any way how nuisance should be used. This is not appropriate or won't be accepted. But I think that if you had asked people pre-Fearn whether this is a way that nuisance would be accepted. The vast majority of tort law scholars would have said absolutely not. We have some clear authority that says privacy and overlooking is not a relevant factor to take into account when determining nuisance. And so it might be controversial, but Fearn was also controversial. And so our argument is that if we're going to stretch existing tort law principles, if we're really going to rethink how this can fit and how nuisance could be used to vindicate specific rights, why don't we specifically stretch them for social equality means, as opposed to kind of protecting people who have the money to be able to afford to bring these huge cases. And for us, there seems to be much more justification to rethink how nuisance is used and this tort property divide to help people who are stuck in dangerous accommodation than there are owners of the multi-million-pound luxury apartments in central London that were the centre of Fearn and Tate Gallery. So we're hoping that the combination of the fact that nuisance has already been stretched in quite a controversial way and the kind of inherent public good and social equality basis of our argument might mean that it's not as controversial as originally anticipated. I look forward to hearing your questions. Thank you.
All right, thank you so much, Vicki and Jodi. A lot of really interesting kind of points there, including that larger point about the role of social equality here in developing torts. So I'll just take a cue for questions, and those in the audience can either just put their hand up or use the handout function on Zoom. I see Jason using his physical hand to go first on the list, so I'll take the cue.
Oh, okay, well, yeah, I couldn't find on the new version of Zoom how to put my hand up electronically. Well, I think it's a really interesting project, a really interesting extension. So I had three comments or three things to think about. So sort of one, of course, I mean, it depends on whether or not Fearn will be accepted, over the long run, both in sort of the English tradition, Donald Nolan saying, well, 10 years from now, it might not seem, it might just kind of dissipate itself, but also in the other Commonwealth jurisdictions. So whether or not the Supreme Court of Canada or the High Court of Australia will accept it might hinder your argument or make it, make it less universal. The other question I had is, and this is a purely kind of Canadian kind of thing, is it seems to me that the core right at issue actually in these cases is not the rights of property, but it's the rights of personal integrity of the people who are living in the buildings. And if that's the case, then it seems to me that the Winnipeg condominium solution actually is the one which is closest to justice and is less controversial. That really what we're trying to do is to get these people to repair things which are dangerous and are liable to fall in and cause people to be injured. And so would that not be an easier solution? Now, maybe it's not easier because in England they don't want to do that. So this is the hook for English law to get in through Fearn rather than through Winnipeg condominium, but as a matter of concept. And the third thing, as a matter of social justice, even, it seems that, if nuisance is a tort to land, and I don't think the English are going to change their mind about that, then it seems to be that we're prioritizing people who have rights in land and their physical protection as opposed to people who don't have rights in land. But on the sort of social justice idea, I would think those who can't even afford to have property rights might be more deserving of protection rather than less deserving. And so those are sort of my three thoughts I had listening to the wonderful presentation.
Should I go first with the last point, and then I can give you the first two? Thank you so much, Jason. I think with your prioritizing people have rights in land, that's been interpreted quite broadly, and so leaseholders and tenants would be included. So it would be protecting pretty much everyone who was in one of these buildings. And I do realize that it is prioritized. There are a whole bunch of other issues with nuisance in terms of, family members and, domestic lodges and the kind of limits on who has an interest in land. But we think at least for kind of this issue for getting rectification of defective cladding, those issues with who has rights and who doesn't are probably not relevant. It's one of the few issues that we can say, actually, there's no real challenge here. But that's not to underplay the fact that because it is a tort land and because you need to have that interest in land, there are a number of people who are potentially incorrectly or unfairly excluded.
Yeah, I was also just going to add to that point that actually I think Sue Bright's work has shown that the tenants in these situations, although they are people with property rights, are still in a very vulnerable position that we should still respond to them. So although they're a somewhat of a property insider, they're in a very weak position in comparison to, for example, the freehold owner of the building or other leaseholders that don't have these issues. So I still feel like there's definitely room within social justice that we should be responding to these people. I have heard about potentially thinking about Winnipeg before, but I think this is because this is a land-based issue in terms of this is people's rights to land. I still think we can come into nuisance. And I kind of agree that I don't know what Fearn will, the results that Fearn will have, and I don't think it will have the same results elsewhere as it does in England. But for now, we've got an issue now, we've got a potential solution. So why not make use of Fearn, at least while it still has standing authority, etc., precedents.
Actually, when I was in Hong Kong last week with Erica, who's unfortunately had to leave, we were talking quite a bit about Fearn, and we were just saying, in a country like Hong Kong, there's no way that everyone lives overlooking absolutely everyone. So even if that concept was to be accepted as valid legal principle, it really could not be applied because it wouldn't be unusual, or you would give rights to absolutely everyone. So there, on top of the is it going to be actually accepted as relevant legal principles, there is the practical issue of, well, how can it be applied in that kind of community that you are addressing it in?
Thanks. I think, Sue, I saw your hand go up as well.
Yeah, thank you very much. And it was really interesting and challenging, particularly for someone who doesn't know very much about nuisance law. And thank you for the reference to the stuff that I've done in this field. But I was wondering if you could just hold my hand a little bit more as a sort of undergraduate who's just coming to nuisance law for the first time and needs a bit of help understanding exactly what nuisance is, right? And that's pretty much me. I'm like an undergraduate coming to it for the first time. So a lot of what you were saying was focused, if I heard it right, on essentially the impact on the claimant. So the effect it has on the person who has an economic property right in the value of the flat and potentially is also living there, right? So there are those twin aspects there about the sort of enjoyment they get if they're physically using the property, but then in any event, even if you're a landlord renting it out, it would still impact on your property right. But what I'm interested in is the flip side, because I don't really get nuisance fully if you don't have an emanation at all. So what is the I guess I may be asking about course about. I don't really know what I'm asking. It's sort of like, what does the defendant have to do in order to create the nuisance? So at Fearn, presumably there was an action on their part in that they allowed people to go onto the viewing gallery, and then once those visitors went on the viewing gallery, the privacy was invaded. In a dangerous building situation, the defendant doesn't do anything. It is so I wrote down, you said is this, I wrote down this and I can't remember what the answer was. Is the state of the premises alone capable of being a nuisance? I can't remember if that was a question you asked or whether you posed that and then answered it. But what is it that is required, so I always think, I can't even remember what Ryland and Fletcher was. Was that sort of some fairground ride that flew off or something like that? Or am I making that one up? There was
Water.
Sorry?
Water, right? Like dam breaking water.
Oh, okay. but there's something, I mean, that's the sort of idea of an emanation. But what do you do if you take away the idea of an emanation? What is it required of a defendant in order for the defendant's property right to be able to be a nuisance to the claimant's property right?
So post-Fearn, I would say something along the lines of the defendant needs to be using their land in a non-ordinary way that then substantially interferes with the claimant's use of land. So it's all about whether the defendant is doing something on their land which is an ordinary common use of their land. So I would argue that maintaining a building structure in a way that is unsafe when you've had calls from the government to repair it and there's duties under the Building Safety Act to potentially take steps to repair it is not an ordinary use of that land that a freeholder would normally do. So my claims are thinking that the individual leasehold flats have a claim against the freehold, it being the freeholder is using the structure in a way that's non-natural. But this is a very new sort of emanation. So historically it was sort of like using your land in an unreasonable way. But now it's more common and ordinary way post-Fearn.
But then, sorry.
There have been cases. No, I know honestly, Fearn is confusing. But there have been cases previously where leaving a building that could collapse, it has been a nuisance. So it's not like a defendant has to do something, but rather what we're focusing on is whether there is something sort of unreasonable and unnatural about what they're doing in terms of the impact it's having on the other plot of land.
So until you added the last example about the building collapsing, I was struggling. Maybe the building collapsing is the analogy, but because the defendant isn't doing anything, the defendant is not using the property. It is and because so the other thing I'm not sure about. So nuisance law looks at land, whereas really we know we're concerned with property rights, and there's they're not really. I mean, the property right is an abstract legal concept, whereas the land is a physical asset, and they're not. I mean, they're not doing. So I mean, sorry, it's very confusing, nuisance law, because it's essentially looking at the land rather than the property right, with the abstract thing. But they're not doing anything. Sorry, Jason's got something that's just popped up.
Yeah, so adopting and continuing a state of affairs.
What is the state of affairs? It's just like unsafe building? Is that state of affairs?
Yes, I think so. I do completely understand that it's a really weird dynamic, and I feel like because we're really on the edge of trying to bring this within nuisance, it's why it feels confusing. But I don't think the defendant needs to do anything because actually the Tate Gallery did everything to stop the problem in terms of they had security guards stopping people to take photos, they were instructing people not to do it. So actually the defendants in Tate were probably doing the right thing in stopping, but rather they were, because the viewing gallery were there with people using it. So actually, even in a situation where they're trying their best, they were still using their land in an inappropriate way. So I feel like they're still charging sort of like ground rent. They're still getting profits, but they're using that freehold in some abstract sense. Even if you think of the sort of Bocado, the people that possess the land, sort of, the title owners possess it, the title owners occupy it. I feel like we could get to something from that sort of case. In a metaphysical way, they're using the land.
We can certainly come back to Sue or Jason for further questions as those ruminate. Yeah, Jodi?
Just to clarify the question about the state of the premises and whether that can be nuisance, we just don't know. It used to be that there was a principle saying the state of the premise alone would not be sufficient to create a nuisance. But there also used to be a principle that privacy and overlooking is not a nuisance and not an interest protected by nuisance. And ironically, when I taught this to my undergraduate students who were nowhere near as wonderful and bright and diligent as you, Sue, I used to say so much about nuisance is unclear, and we don't really know where it starts and where it finishes. The one thing we do know is it doesn't protect privacy and overlooking, because we have clear cases that say that. Now, fortunately, I don't have to teach that in the UK post-Fearn, because now I don't have anything that's clear and certain about nuisance. But it did used to be clear and certain that the state of the premises in and of itself wouldn't be sufficient. However, in Fearn, in an obiter comment, Lord Leggett opened the door for that and said, actually, he did not want to rule out the possibility that in and of itself, so the unsafe state of the premises, the unsafe design or construction of a building could in and of itself be a nuisance. And that's a door that has been left open.
Okay, on to Zoe with her virtual hand.
Okay. I found my hand. I was just really excited. I just wanted to show off I could find the hand. Right. So I agree. Nuisance is so confusing. Every time I think I get it, it just slips away from me. So, I mean, I actually, like, I was like, I had the typical kind of tort lawyer reaction. We're like, no, that can't be right. And then I was like, oh, yeah, okay. I can see how the landlord and the tenant can be kind of in some ways like neighbors in this way. So one's use of their property unreasonably interferes with the other's use and enjoyment of theirs. Like, I'm actually okay, like, get that. My problem is, like, I think Fearn is wrong. Right. So when I got off the boat, like, I was like, I unnecessarily am like unsympathetic because I just think like Fearn is clearly like wrongly decided. It's not nuisance. There's a whole bunch of problems with it, right? Emanations, that something is important about emanations. It's just that there seems to be no recognition of a right of privacy. That is actually what's at it. So we're using nuisance as a way to get at the real right in question. So one of the things that I think, like, one of the problems, like the nuisance analysis, though, is like something maybe you talked about it, but I'm not sure like when the wrong happens. Right. And so, I mean, nuisance is tricky, right? Because it's a continuing wrong. It happens, but something has to happen, right? So like when you talk about like the weed that invades, well, what's happening is like the weed actually is coming over your property and now is continuing to come. So it keeps on growing. The roots they're growing under, that's all happening. But here it's like these latent defects, which may or may not like culminate in actual damage. And so when they do, I feel like that's an easier case than I'm all with like Winnipeg condo, although I can't remember that because I got taught it so long ago. And I was texting Jason, like, what happened in that case? Well, who won? Isn't it something about the things falling out versus falling in? And he won't respond to me. So he won't let me know the answer, which is kind of frustrating. Right. But like here, I'm like, well, when does it happen? Because you do need damage for nuisance. And whether damage can just be a loss of amenity, I think I'm not so sure about, hence like my lack of so I was thinking when Sue mentioned rather than Fletcher, I was thinking about a different Fletcher. I was thinking about the Quia Fletcher. So this is like they're making this like fine, lovely paper to make out like cigarettes out of or whatever it is in the good old days. And upstream, there's this horrible like, I can't remember what there's some horrible green oozing disgusting putrid liquid that's sitting there, and they're worried that this liquid is going to come into the river. I can't remember which river it was. I don't remember anything these days. Too much administration makes my brain mush. It's going to come to the river and it's going to destroy the quality of the paper. So they asked for it, like, but it hasn't happened yet. Right. So this is like, so it hasn't happened yet. As you know, like the test for that is really high, right? To get that kind of injunction, or as you say, maybe an order for rectification, like, they failed in that case, even though it seemed really quite likely that this was going to happen. Like there was actually no plan to like move the green oozing sludge somewhere else, right? But here, like, so I just want to know, when do you think the wrong happens? Whether like this kind of like a different type of injunction would be required rather, because it can't be a nuisance until something. Maybe I'm wrong about nuisance, which is because nuisance is hard, but it doesn't seem to be an actual nuisance until some damage actually happens. Like the cladding falls on my head, and like we don't want that. Like that's not what you want. You want it to be like prophylactic, right? So I'm just wondering how that works on your account.
So sorry, Jodi, just to interrupt. I am going to take some guidance from the Supreme Court case of Davis, which I didn't go into. So that's a Japanese knotweed case. And in that case, they said that the wrongdoing happened when there was publicly available scientific evidence of the dangers that the Japanese knotweed could have, and you failed to rectify. So when you knew that this could be dangerous and have impact, but you didn't do anything, that's where they said that nuisance started. That's where they said the wrongdoing and nuisance started.
But the knotweed had crossed over, correct?
Yeah, it had already done it, but they said
so
that you were not liable until you knew the publicly available information. So I feel like we can do an analogy there. So the cladding is a wrongdoing when there's publicly available information about the dangerousness of this and the defendant fails to take action.
Okay.
That's continuing the nuisance. That's continuing a nuisance.
Yeah. Actually, so at that point, they're continuing.
I don't think that part is particularly controversial
Okay.
because they're accepting and continuing the state of affairs. They're not fixing the defective premises. They know about it. There's so much public information about it, and they have a duty. We're arguing, and then they're not fixing it.
I guess I'm just such a physicalist. I'm like, okay, I see the knotweed creeping over, and like I get that like just the creeping over might be fine, I guess. Although I could still. But okay, here's the difference. Like, so if there's knotweed creeping over my property, I don't even know what this looks like, but I guess it's bad. I could like go out there and I could hack at it, and like my neighbor couldn't complain about it. But in this situation, it couldn't be the case that the leaseholder could go in and rectify the defect, right? So there's a way in which it can't possibly be a wrong. Yet in some ways, if there's no kind of remedy of abatement in that way, that's my I get kind of stuck there. I don't know, maybe I'm just being dense. It's possible. Jason's nodding. He's not nodding. He's nodding in his eyes. I can see. He's my colleague.
Maybe ask something that's kind of in the same vein, maybe as what Zoe's saying. So the issue of whether like the mere exposure to a danger or like the failure to rectify an exposure to danger itself. I wonder whether like imagine a landlord is sending emails or letters to a tenant, for example, saying, look, I am going to collapse the building on your head over and over again, even though like there's no real concern about cladding or not. And like, let's set aside whether this is a kind of harassment issue. This is just something about the landlord as we can treat it as an abutting property owner, creating a risk or fear on the part of the tenant. Does that fear have to materialize, right? Or is it just that threat, that exposing them to that potential threat enough to constitute a nuisance? Even if we don't even say it, there's no cladding issue. It's just the threat, and that goes to the question of what's the interest being protected is it a proprietary interest or is it a bodily integrity? Yeah, so maybe that's just another way of kind of getting at, I think, Zoe's concern.
Yeah, but I think the difference there is that's not interfering with your property right in the same way. That's quite a personal issue. Whereas I feel like I don't know how to articulate that. I think there's a difference.
It seems to me like somebody peering into you and like a zoo, right? It's like I always have to worry about whether, I'm not wearing a garish orange tie or something like that. Not to mention the things that I could otherwise be doing in my apartment, right? Here, I always have to worry about whether this landlord who has probably more power and money than me really will, I don't know, set loose some cockroaches in my apartment or something like that. That's really kind of preventing me from being able to. If I'm really being threatened about about vermin in my apartment, then I just can't have a pet because the cat food will attract the vermin that is being threatened, right? And that limits my ability to do what I want in my premises. So that kind of case actually seems quite even closer to Fearn than the cladding thing. But if you're right about cladding, then all three of those should be continuous. I think is my suggestion. So maybe Jason can help us with his structural hand.
Well, I can't help with that actually, but I had another question. I don't know if you guys had thought about it or not because I didn't really have a chance to look at the paper. Is what about the principle in Goldman and Hargrave that sort of what somebody has to do in relation to a nuisance that they didn't necessarily cause themselves, but which is sort of being thrust upon them is sort of semi-subjective rather than being purely objective. So I just wonder if that is focused in your analysis. What we could expect of a very wealthy landlord with a very expensive building might be different than we could expect with somebody who is not a wealthy landlord and the building is their only asset. And the second question I just had, this because I don't know the social facts in England. People who are in social housing in England, would they have a lease, or would they be licensees or something? And if they are, then it raises my question again. What are we going to do for them if they don't have a property right in their flat? So those are my one thought and one question, or two questions and one thought. I don't know.
I can start with the second one. And in fact, when I originally came to Sue and Ben's project, I wanted to write on people in social housing and the impact that Grenfell and Defective premises had on them, but ended up writing on collective redress instead. So there's still a lot of questions about it. I think that is a paper in and of itself, largely because there's not just one form of social housing. There is multiple different kind of council and building authorities, and they're all kind of structured in slightly different ways. But in general, the main form is to give someone kind of a life interest in it. And if you're in the like traditional social housing in the UK, it's quite difficult. People's income can increase. They can have a family flat and the kids can move out. And it's quite difficult to remove that interest from them. But if it's not about diminution in value, and they don't have to sell or anything, they could, in some instances, actually be in a slightly better situation than people who have bought the property and have a mortgage. But in some instances, they'll obviously be in worse. So it's quite a confusing question. So I might just put that aside for now. But you're right, it is really interesting.
Yeah, and I really tactically, if you ever look, if you know the actual paper, I really tactically try to not deal with social housing, and that's why we were doing private blocks, because actually we feel like that's where the answer is. Interestingly though, nuisance, it needs an interest in land or exclusive possession. So most people that would be in social housing would probably fall under the exclusive possession unless they had a license that prohibited exclusive possession. So they probably would be able to bring a claim in nuisance, but they might not have the same sort of like, well, it'll be potentially the council be rather than the independent landlords. So that might be a bit trickier. So we sort of try to sidestep that issue. And that's one of the critiques we say in the paper. Actually, this is an answer for a small subset of the buildings, because it's not an answer for those that have, for example, invoked the right to manage and they've, bought out the freehold. It's not going to help them because they've not got a freeholder to bring an action against. It might not help some people in social blocks. So it's actually quite a small subset, but we still thought it was a small subset that this might be able to help. So we thought it was worthy of trialing. So sorry.
Yes, do. Please.
So the first question I have is for Zoe and Jason, which is, how did you manage to raise your hand?
I went to React and I pressed React. And I pressed React and a little thing pops up and it says raise hand. And I can also do other fun things like.
I just did that. Sorry, I'll stop playing now. Okay, so when I went on, okay, I can see React. When I went on it before, you have to click on it the right way. If you click on it the wrong way, you don't get the raise your hand thing, you get something else. That was what was confusing me. Right, now to substance. Sorry about that. So one of the things that sort of Ben and I have been playing with and intrigued by is this whole relationship between, so the book that Jodi and Simone have done chapter in is looking at, it's looking at private law not just as a sort of tort law or contract law or property law, but how these subjects interrelate. And I think this is an area where the interrelationship between property rights, and I mean your work, but also the whole topic, the interrelationship between property rights and other private law rights and duties is crucial. And so and I think it was you, Vicki, rather than Jodi, I can't remember now, who just said something like, if it wouldn't apply to a right to manage situation. And of course, well, in quite a lot of these, it depends what we mean by that. So for those who aren't English lawyers, I mean, we do have a really quirky way of owning apartments in that you have a long lease from a freeholder, as against all the unit owners collectively, for example, having some other interest in the building as a whole. But that does happen in England, that the leaseholders may, or some of the leaseholders may collectively own the freehold. And so one of my questions was, what happens if, so I am a leaseholder, so my flat is affected, but I am also one of the number of leaseholders who also has a share in the freehold. So I am also in community with others, the freeholder. And I don't know how tort law would respond to that, because there will be other potentially leaseholders who have units in the block who don't have a share of that freehold. So you can get subsets of leaseholders having a share of the freehold. I have no idea what that does to your understanding, or any understanding of nuisance law in this situation. The other thing is that does the landlord or the freeholder have to have the power to remediate before they can be liable in nuisance? Because sometimes under some leases, the property right is held by the landlord. Let's just call him the landlord for now. But the power to, or the duty to do things may fall on a management company who's also a party to the lease, I think. I mean, I haven't really thought this through. And I don't know if that would complicate how nuisance would apply in those situations.
In short, yes, I think it would complicate the situation quite heavily. So I don't think tort law would deal well with the I'm both parties, but in a subset. But I imagine it depends on how the right to manage is input, like how that thing is seen. Because obviously, if it's a company, then it's a separate entity. So potentially that's different. If it's, if they joint tenants of the freehold, that's also potentially going to be different. So I think that is an important question, and that's why, again, I tried to sidestep it, because I felt like it wasn't going to be helpful in that case, because if I'm the leaseholder and the freeholder, then I can't bring an action against myself to fix something that I've not done. But I hadn't thought about when there is a limit on the power to remediate. But I think that's also interesting, surely, with some of the stuff in the Building Services Act, which are putting sort of like trying to put duties on people to remediate. How does that work if they then don't have the power? Are they liable for some of these Building Service Act duties?
Trying to unmute then. I would need to look at the relevant sections, but they very carefully define who is well. Well, firstly, it doesn't impose a duty to remediate on anybody under the Building Safety Act. There is no duty to remediate. In fact, that's the starting point. That's a problem. There is no duty to remediate. So the only source of a duty to remediate would be either if in the contract of the leasehold contract, you could point to the obligations that the landlord has undertaken as incorporating a duty to remediate. But on my view, from day one after Grenfell, I was always arguing, I think that the majority of leases, it's quite hard to prove that. There is a duty to remediate. So if we get rid of the leasehold contract as a source of the duty to remediate, the only other source is potentially the Building Safety Act. But the Building Safety Act doesn't impose a duty to remediate. It imposes a duty on the principal accountable person or the accountable person, I can't remember the definition exactly, to conduct a building safety risk assessment and to take action to reduce those risks and that emerge from their safety review. And that may implicitly lead to a duty to remediate, but it's not actually a duty to remediate as such. It's that you have to assess the safety of a building and then not necessarily eradicate all the risks, but eliminate the worst risks, say. So this idea that there's a duty to remediate is, I mean, you'd think there would be. It sounds pretty obvious. Of course, there ought to be a duty to remediate, but it's actually quite hard to point a finger at one. Anyway, and get back to where I was trying to get to with that, is the person who has that duty is not necessarily always going to be the landlord. It's the one who has I can't remember how it's defined, like power to repair, maintain, or whatever it is. But I'd need to check out the wording. Yeah, so I think this is all really interesting. But the other thing is, let's go back to if we can, Jodi's questions at the end, her concluding thoughts, or maybe it was the slide before the concluding thoughts. I think I can't remember what it was called, ongoing challenges or something. The service charge issue is, I mean, maybe that doesn't matter for these nuisance claims, because and again, for those who aren't English property lawyers, this is all, well, I mean, I guess it happens in any condominium style block, that when work is done to the block, it gets charged through the service charge to all the unit owners. And essentially that's obviously what works with a lease, although there are some protections in place now under the Building Safety Act for some leaseholders. Very, very complicated. But presumably that doesn't matter, because what you're trying, it doesn't matter that they may end up paying for the work. What you're trying to do is trigger an obligation to do the work through your, is that what your objective is? An obligation to do the work, even if they may end up having to put their hands in the pocket to pay for it.
Then obviously also the Building Service Act, some of the leaseholders will then be protected from those service charges. So I sort of, at the end, we sort of say, well, potentially this works together, so it makes them do it, and therefore the Building Safety Act will then prevent at least some of the leaseholders from having to put their hands in the pocket. Yes.
I had a separate, or sui generis question, if I could jump in. Maybe it's related to some stuff to do the same. But like one of the forms of litigation in and around building safety that I'm familiar with in Canada is like building inspection cases. And so I think the project that you guys have is starting with how could we extend nuisance to capture these sorts of issues. But like I guess I wonder, and maybe this is just a question, the prior issue about negligence on building inspectors for failing to uncover these sorts of problems, like is that seen as inadequate for dealing with these? And I think that maybe the way of looking at it is to say, well, a building inspection is about uncovering the sort of defective cladding and whether it's known or not. And there could be liability on government authorities for failing to properly uncover that, based on statutory duties to do the proper inspection. But then maybe what you're interested in is a separate question, and this came up a bit in the discussion, like once it's already known that there's a building defect and there's a failure to remediate on the part of the landlord, then that's where the question of nuisance comes into the picture. When we're sort of stepping back, and this was something Zoe, I think, mentioned, the damage has occurred, somebody's injured, then I think at that point, these two questions can arise. Like, was it known or not? In which case, if it was unknown, it might have been discovered through an inspection. Negligence could be useful to the claimant for getting damages. But if an inspection was properly carried out and everybody kind of knew that there was cladding problems, and like the authorities performed all the remediation they were statutorily obligated to do at that point, then there's a question of nuisance on the part of the landlord. So I wonder if like there's that sequencing of things makes sense from your perspective, or if that's just something that like should be obvious to me. And maybe on at the same point is like, does occupiers liability help here at all? Does it have any application here? And one way of looking at this is to say if we're going to extend Fearn, we're sort of viewing the landlord and the tenant as having property next to each other in a way, so that one property can affect the other. But why not take a view of property here where one property is nested within the other? And this is where occupiers liability can maybe do some work, where if you just invite somebody onto your premises, then you have a duty of care towards them. And so maybe the landlord can be seen as inviting a tenant into the flat, and so sort of having duties there. It doesn't seem to be nuisance based, it's something else. I'm just actually curious about that point. So I think those are my two questions: building inspections and occupier liability.
I think we're going to have to think about the second one. That's a bit of a curveball. So Vicki and I might have a chat about that one. The building inspectors, that's been quite successful in Australia and New Zealand. That if there's been a defective a building inspection, then there is potential rights. The issue that has been encountered is this pure economic loss or property damage? So it brings up another tort issue there. But I guess we probably do need to think through the timing of that in terms of kind of when it's known and when the breach occurs. So I think we can think through that from the property inspecting perspective. But I don't think that we have the energy at this stage to talk about how this might potentially have duties on property inspectors, unless Vicki is much more energetic than I am.
No, but I feel like there's also going to be an issue with the nested property and being invited on because the tenants hold a property right. They hold the best property rights. They have the right to exclude the landlord from their property. So I don't see how we can work on occupiers' liability in that context, though. But if anything, the tenants would have the responsibility of that. I need to look back at occupiers' liability because I haven't thought about it in longer than I'd care to admit.
Yeah, I think we need to stop and think about that one. But thank you.
Okay, I think Jason, maybe I saw that your hand was up, but maybe went down.
No, it's fine. It's just a very quick question. I just wondered if one of the benefits from a functional perspective of viewing it as the tort of nuisance is a way to access insurance for somebody who would be found liable for it in a way that now you're describing how all these housing Sue was describing how I have to reimburse the owner for the things they have to do for my lease. I'm just costing myself money actually by suing somebody in nuisance. But if there's insurance backed some way, then I'm not actually costing myself money. It's costing the insurance company money because they have to remediate something that would be tortious otherwise. So I didn't know if that figured into your analysis or not, or whether or not that might be a practical reason why we'd prefer doing this rather than leaving it to some other mechanism.
I'd say I had similar thoughts that even if you were the same party, if you had landlord insurance or something to protect you, then maybe it would be worth it. But again, I think that's something that we're going to have to think about and look into.
So maybe we can begin wrapping it up here. I think it's been almost about an hour of Q&A, so hopefully that's been helpful for you guys. And I was kind of the last thing I wanted to mention at the end was, I guess it's right on point for the speaker series to think about why not extend Fearn in this context because of the way this is a way of promoting social justice. So thanks so much for that really interesting talk, which spanned property, contract, and tort, I think, in a lot of different ways. So thanks very much. And to Vicki, have a good night, and to Jodi, have a good morning. And again, thanks for accommodating in your different time schedules.
Thank you very much for inviting, and thank you for the wonderful questions and comments. I'm going to take the fact that you've attended as implicit agreement that you will happily read and comment on the paper once it's completed. So we will be spamming your inbox in the near future.
I look forward to it. That's awesome.
Yeah, nice seeing you guys again. And nice meeting you, Sue, for the first time. I don't think we've ever met before.
Nice to meet you. Bye,
and Jason, I will reply to your email after an embarrassingly long amount of time. Thank you for reminding me.
No problem.
Thanks very much.
Bye, everyone. Have a good weekend.